Good morning. Actually, what happens when some hurdles are being caused, some ban or barricade was there, which may stall our practice because we are answerable to our client. Then we used to work out other alternative remedies. But some lobby advocates may approach their mentor judges and after complaining about the difficulties of recent judicial precedent and other things, that will be get over. Just like earlier, warrant recalls was not allowed. Then that was also get over, stating that some dissenting judgment unpermitted to, like these cases like not to harass. Not to harass was prevailing before Kerala High Court, that is now being implemented here also. See, when NDPS Act bail was very difficult. Uh, I filed a bail application under 167 class 2, stating that 90 days, that time 90 days was there. Once these amendments were not there, then that was rejected by the special court. I went to Honorable High Court and I vehemently argued, stating that the bail under section 167 was on the ground of exhaust of power of the land magistrate in extending the remand. His power to extend the remand exhausted. So there is absolutely no power to remand except to release on bail. That time also my case was not accepted, but subsequently the Supreme Court rightly held that 167 class 2 applicable to NDPS case, not only all TADA, FEMA, whatever may be the case. Here, see, this judgment is most important for you. Though this case is pertaining to Commercial Courts Act, because there was delay in filing written statement, Commercial Court Act has got prescribed time of limitations. See, if there is no prescribed time of limitation and the extension of that limitation, the Section 5 Limitation Act is applicable. There you need not wait for any days, even 1000 days, 1012, more than 3 years days were. Justice Batmini used to say that so far MACTOP and appeal against the convictions, close the eyes and allow the condoned delay. That was the learned my lord Justice Batmini says they used to say. Here, sometimes in some specific special act itself have control of limitation, like Commercial Court Act says this written statement must be filed within so and so date. Thereafter, only within some period of extension is only allowed. Otherwise, that was not. In that case, multi number of cases were there. Supreme Court at Avimand again said. Here you can see the defendant sought exclusion of time which was granted by the Supreme Court while dealing with suo motu writ petitions when the pandemic was very vigorous. So that therefore they say Disaster Management Act Section 5 and 6, Limitation Act Section 6 were discussed. Here they say Section 5 Limitation Act should also go with Section 12 to 15 where extension of limitation was there. So Limitation Act is plays vital role. It's not that in civil cases also, kindly note that criminal cases also you have to go through with the law of limitations. Here section 12 to 15, if you are approaching wrong court or so many other incapacity, these things will give extension of period. Like that, here the Supreme Court has held section 4, section 4 of the Limitation Act, where the prescribed period for any suit, appeal or application expires on a day when the court is closed. The suit, appeal or application may be instituted, prepared or made on the day when the court reopens. Explanation: a court shall be deemed to be closed on any day within the meaning of this section if during any part of its normal working it remains closed on that day. So they say, because here they also says what is a fantastic argument of the Supreme Court judge Dinesh Maheshwari and Vikram Nath. You see, in P. Ramanath Iyer's Lord Lexicon, the concept of dies non judicious is explained under inter alia in the following term: dies non, Latin word, a day which is regarded by the law as one on which no judicial act can be performed or legal diligence used. Trainer, shortened form of dies non judicious. A day not judicial, a day exempt from court procedures such as holiday or Sunday, a day on which court do not ordinarily sit or carry on business, a day on which general business may not lawfully transact. So by all these things, the conclusion was, we are unable to approve the order dated passed by the trial court and confirmed by the High Court. In our view, written statement already prepared and notarized by the defendant appellant deserve to be taken on record, and trial court deserves to direct to proceed with the matter accordance with law. Thereafter it should be dealt. Therefore, they say the ratio was that the period of Corona declaration should be considered, and somewhat extensive argument was there that you go through the judgment, because I do not want to confuse that non-favorable ratio, leaving you to understand the same thing for you. If you go through the entirety of judgment, you can understand the way in which we can get over with delay. See, you can use this judgment, that is what I want to pursue you. You can use this suit even for a suit for filing. There is a limitation for suit filing also. That for that also you can get over with by applying this judicial precedent. Therefore only I say, if suppose you want to file suit for money or some suit for declaration, whatever it may be, your cause of action expired during the period of COVID, you can use these ratios paragraphed in this judgment, and you can claim that you have got right to file suit after expiry of. Like that, you can file criminal complaint for criminal offences, 138 negotiable instrument. Therefore, kindly go through this judgment, at least the index, and again go through the judgment, so that you can develop your mind to get over with any cases which is time barred during this COVID period. And don't think that COVID is over. No, COVID is hurriedly running towards it. It reaches Kerala, yesterday Kerala. So I hope it will reach in Tamil Nadu also, and the casualty at Kerala is very heavy. I do not know what to do, what not to do. Okay, I today I will a live regarding certain major things, why the war is there and all those things. I will come and live a different, not in this law learning program. So I think you understand the way in which the Supreme Court held that during the period, that is, they said 15/3/2022 to 2/10/2021, the COVID declaration was there. Subsequently, they relaxed it and whatever not. So you try to work out your remedy, not only for this filing of return statement. You can use this for all purpose. Even summary chapter suit also you can use it. Best wishes.